A very good afternoon, esteemed guest, my other speakers, chairperson of this session of the international seminar, co-chairpersons, and organizers of this international seminar. My greetings to everyone. Today I am going to talk about feminism and subaltern issues, uplifting the national consciousness. My talk interrogates the convergence of the feminist theories and subaltern studies as a transformative forces in the constructions of national consciousness. If I drawing your attention upon the intellectual traditions of Gayatri Chakraborty Spivak, Antonio Gramsci, Bhimrao Ramji Ambedkar, and Mahashweta Devi ji, it argues that the genuine national upliftment is impossible so long as the voices of women, Dalit, Adivasis, and other marginalized communities remain abstemically erased from the dominant political discourses. I want to speak that the subaltern women occupies the doubly dispossessed position, subjugated both by the patriarchal social order and structural violence of caste and class, and that her empowerment is the indispensable precondition for a truly inclusive national identity. Employing a post colonial feminist lens, my talk, also examines the complicity of law in perpetuating the subaltern silence while identifying the constitutional jurisprudence, grassroots activism, and pedagogical reform as pathways towards emancipatory national consciousness. If I say the nation, as we imagine community, and in Benedict Anderson formulation, is perpetually in the process of becoming. Feminism and subaltern studies as intellectual and political movement, they share a foundational commitment. The instance is that no project of national liberation or democratic consolidation is complete unless it reaches to those who have been most thoroughly dispossessed. Now, the paper which I have written in this reference, it actually contends that the upliftment of national consciousness is not merely a cultural or a symbolic aspiration. It is constitutional, jurisprudential, and political imperative. To build a nation in a fullest sense is to construct a polity in which the subaltern women can speak, they can be heard, and they can be represented. The paper I have written in this reference is divided into 5 parts. First, it situates the theoretical framework of the intersection of feminism and subaltern studies. It then examines the specific predicament of subaltern women in India and then proceeds to analyze the role of law in both silencing and potentially empowering the marginalized, subsequently identifying some of the key sites for transformation, and concludes with a vision of emancipatory national consciousness. Now, the concept of subaltern, we all know, derived from the Gramsci Prison notebooks and radically revoked by the subaltern studies collectively, and Spivak refers not merely to those who are economically subordinate, but those who are structurally excluded from the circuits of hegemonic power, those for whom representation in both the political and discursive sense remains a size of perpetual deferral. Kimbray's Crenshaw's theory of intersectionality, the understanding that operation of race, class, gender, and caste, they do not operate in parallel but in mutually constitutive ways, find its most vivid expression in the Indian social formation. the Dalit women, the Adivasis, the Muslims women from a lower economic stratum, each occupies a unique locus of intersecting vulnerabilities that cannot be addressed by any single axis analysis of either feminism or caste politics alone. Indian feminism has itself been subject to this critique. The mainstream women movement, particularly to its early post-independence phase, was predominantly led by upper caste educated women, whose priorities, personal laws, property rights, professional equality, while legitimate, did not always resonate with the lived experience of women at the bottom of the social hierarchy, for whom the more pressing concerns were survival, land rights, wage parity, sexual violence, and caste-based atrocities. Dr. B.R. Ambedkar ji, whose feminist credentials are frequently under-acknowledged, identifies this tension with characteristic clarity. His critiques of Hindu social order was inseparable from his concerns for the position of women within it, and his instances on the annihilation of caste was simultaneously an argument for women liberation. There are multiple areas of dispossession. The subaltern women in India, they navigate the landscape of compounded disadvantages. There are considering the following dimensions: the caste violence, the Adivasis displacement, the economic marginalization, the patriarchal structures, the epistemic violence. And if you see the literature witnesses through Mahashweta Devi ji, Hazar Chaurasi ki Maa, Draupadi, Rudali, they constitute an urgent archive of subaltern female experience that legal and policy discourses has largely failed to engage with. Devi's Draupadi, the tribal woman who refuses to clothe herself after being gang raped by the soldiers, enacts a radical inversion of the subaltern silence. Her naked body becomes an accusation, a refusal of the very framework that has violated her. This is the moment when the subaltern does speak, not in the language of the oppressor's court, but in the language of the body, of the defiance of an insurgent dignity. National consciousness that cannot hear this voice, that cannot read this body as a political text, is impoverished at its very foundation. Law, you see, is both, as an oppressor, as an emancipator. Law is never a neutral instrument. The Indian legal system, despite its transformative constitutional promises, has at various junctures reproduced and legitimized the marginalization of subaltern women. We have several restrictions which are very instructive. The codifications of personal laws. Hindu, Muslims, Christian has frequently invoked custom and traditions to deny the women equal rights in marriages, divorce, maintenance, and inheritance. Even the Constitution Article 14 and 15 mandate equality. The historical relevance of the courts to recognize marital rape is still not criminalized in India, reflects the patriarchal presumptions embedded in the legal order. The procedural barriers to justice for Dalit women, survivors of sexual violence, including the police inaction, hostile medical legal framework, and the social pressure of the witnesses, render formal legal rights. Forest Rights Act implementation, failures of dispossessed Adivasis women of their resources base, notwithstanding with the Scheduled Tribe and other traditional forest dwellers' recognition of Forest Rights Act 2006. And yet, the Indian Constitution remains, as Ambedkar himself envisioned, a transformative document, one that contains within it the seeds of radically egalitarian social order. 14, Article 14, 15, 16, 17, 21, 23, and the directive principles collectively constitute what Uday Mehta's, if you see, calls a grammar of justice that progressive jurisprudence has increasingly deployed in the service of subaltern claim. We have landmark decisions. Vishakha state of Rajasthan later on came into the form of Act, that is the Sexual Harassment Prohibition Redressal Act of 2013, which acknowledged the sexual harassment as a violation of women's right to equality and dignity. Now, facing Johar case, Nalsa judgment on transgender's right demonstrate the capacity of constitutional court when sensitized to subaltern experience to advance the transformative justice. The Protection of Women from Domestic Violence Act to the Scheduled Caste and Scheduled Tribe Act of 1989 and its 2016 amendment, Sexual Harassment Act. These legislative developments, however imperfect in implementation, represents the ongoing negotiations between the subaltern feminist demands and the state power. The most powerful argument against Spivak's pessimism about subaltern speech is the historical and contemporary evidences of subaltern women's own collective actions, the Chippo movement and the anti-Arik agitation in Andhra Pradesh, the Gulabi gang in Uttar Pradesh, the formations of Dalit women's Sangams, and the protest of Adivasis women against displacement. All this testify to what, James Scott calls the weapons of the weak, or rather something stronger, the organized political agencies of those whom dominant discourses has sought to render speechless. The 73rd and the 74th Amendment, which mandated the reservations for women in Panchayati Raj institutions, transformed the political landscapes at the grassroots levels. We have Women Reservations Bill now, which has came into an act, responded a very historic step toward the substantive representation at the national legislative level through its implementation is deferred to a post-delimitation exercises. The principle it enshrines that a democracy in which women constitute half of the population and disproportionate shares of the most vulnerable are structurally underrepresented in parliament is a democracy that has failed its own foundational values is beyond contestations. The central argument, of my paper may be stated simply as a national consciousness that does not center the experiences, demands, and the vision of subaltern women is not a national consciousness at all. It is the consciousness of the privileged few dressed in the language of the universal. The task of uplifting national consciousness then is not a task of inclusion, a matter of adding previously excluded voices to the unchanged mainstream, but of transformative. It requires us to ask what a nation looks like from the vintage print of the Dalit woman, laborer in a brick lane in Bihar, the Adivasis woman whose forest has been acquired for a steel plant. The Muslim woman navigating the double marginalization of communalism and patriarchy, the transgender woman who has been rendered legally invisible for most of her country's history, feminism in its most rigorous and intersectional form, and subaltern studies in its insistence on the political voices of those at the margins together provide the intellectual and political resources for this transformation. Law, despite its holistic complicity in subaltern dispositions, contains within its constitutional DNA the possibility of an emancipatory jurisprudence. The pedagogical, political, and social work of activating that possibility is the work of our generation. When subaltern women write their own stories in courts, in parliament, in classrooms, in literature, and in the streets, the nation will have to begin to fulfill its founding promises. That is the consciousness we are called to uplift. With the African proverb, I end my talk. Until the lion learns to write, every story will glorify the hunter. Thank you. Thank you for your patient hearing. Thank you so much.